Welcome back to Really Legal. I'm attorney Ethan Bearman. April 4th, yesterday, Judge Aileen in the Southern District of Florida issued a ruling related to the Donald Trump documents case in Mar-a-Lago. I'm going to give you the good, the bad, and what's next. So you might remember this case. This is Donald Trump, former president, brought lots of records, classified records, top secret records, including nuclear secrets allegedly related to one of our allies, and kept them in various places throughout Mar-a-Lago, and allegedly without any permission to do so. And what's so important here, when the National Archives tried to get those documents back, he lied about it, he allegedly, and he also then obfuscated. He did not cooperate. And it took special action before those documents got returned. And so there is a criminal case coming out of that. And it is in the Southern District of Florida in front of a judge named Aileen, who is a Trump appointee. And just very bluntly, from an attorney's standpoint, has done things very, very unusually. This is an exceptionally unusual case. Donald Trump has pushed our legal system in ways that is exceptionally unusual. And what has transpired in this case is also exceptionally unusual. You'll remember as far back as 2 years ago, when those documents were recovered by the FBI, she appointed a special master and was trying to say that there were special rules that applied to a former president regarding this, and the 11th Circuit had to overrule her. She's been overruled twice by the 11th Circuit. So let's get to what happened yesterday, and there's one piece I have to set up first, which is just a couple of days ago, Special Counsel Jack Smith and his team filed a motion to the judge to kind of force her hand to give a decision. What's really, really, really weird in this case, and you may know this just from your general knowledge, there's something called jury instructions. And us attorneys, what we do is we either jointly or we separately, and have the judge rule on it, submit jury instructions before a trial. Usually it's done, let's say, within the last month before a trial. Whether it's state court here in California or federal court, we do that and we submit them, again, whether it's jointly or individually, and have the judge decide what the instructions are going to look like to the jury. And this is what tells the jury, hey, here are the elements, here are the specific things that must be proven. All of these things must be proven for this cause of action, this count, to be able to find them guilty. And in this case, it's a criminal case, so it's beyond a reasonable doubt. And so that is really important, what we tell the jury. And that's often a source of battles between attorneys. Sometimes it's not. I mean, sometimes it's really straightforward, but sometimes it's going to be a battle. And as it appears to be with everything with Donald Trump, everything's a battle. So there's no agreeing to what the jury instructions are. So that's what jury instructions are. But what's really spectacularly weird in this case, I haven't heard of this. Everybody I've talked to in the legal areas, lawyers, they haven't heard of this. We don't even have a trial date set yet in this case. And Judge Cannon asked each party to submit their proposed jury instructions. It's not time for that. We haven't even made it all the way through discovery. We don't even know exactly what counts are going to hold, because there's going to be things that are called motions for summary judgment that are coming. There's a lot of different things that can happen between now and those 30 to 60 days before trial. So we don't submit the jury instructions. She asked for a submission of jury instructions to, in her words, is to clarify each side's arguments. Well, that's done through briefings. We brief that. We actually argue the law in front of the judge through motions that are put before the court. And so that's what's spectacularly unusual in this case, is that she asked for it. But what's particularly problematic of asking for jury instructions at this stage would be if Judge Cannon were to accept the jury instructions as they are written, and a jury is seated and then says, oh, these are the jury instructions I'm going to use. It's something called double jeopardy. The special counsel, the prosecutors, cannot at that point appeal. So Jack Smith, the prosecutors, need Judge Cannon to rule on these jury instructions. Well, she issued her order yesterday. There were two things that she was ruling on. One was Trump's team said Presidential Records Act doesn't apply at all. And I mean, that's ridiculous. He was no longer president. There is no evidence in the record that he had, I mean, other than an argument, but there's no evidence in the record besides an argument that he had declassified these documents while he was still president. So I'm going to read you some sections here from Judge Cannon's order. And this first part is related to the Presidential Records Act. And I quote from Judge Cannon, "Fully advised in the premises, the motion is denied." That's for the Presidential Records Act dismissal. "Bound by the four corners of the superseding indictment, counts 1 through 32 track the statutory language and essential elements of the charged portion of 18 U.S.C. 793C. In other words, they allege sufficient facts to maintain the causes of action, the counts, 1 through 32 related to the Presidential Records Act to stay. She also went on to say a little bit further down, those same counts make no reference to the Presidential Records Act, nor do they rely on the statute for purposes of stating an offense. As for the remaining counts against Donald Trump, they too track the applicable statutory language and essential elements of the charged crimes. For these reasons, accepting the allegations of the superseding indictment is true, the Presidential Records Act does not provide a pre-trial basis to dismiss under Rule 12b3bv. Wow. Either as to counts 1 through 32 or as to the remaining counts, all of which state cognizable offenses. Again, all you have to do is state what it is, and there's sufficient allegations to survive the dismissal. So then she goes on, this is the issue regarding the jury instructions. And I'm telling you, this is the really big issue. And it's going to turn into a big battle between Jack Smith and Judge Cannon and potentially up to the 11th Circuit. But here's what she says in the ruling, Judge Cannon. The special counsel demands an anticipatory finalization of jury instructions prior to trial, prior to a charge conference, and prior to the presentation of trial defenses and evidence. The court declines that demand as unprecedented and unjust. I just have to say, I've talked to many people, and it is unprecedented, at least from my experience and the people I've spoken with, that you're demanding jury instructions this far ahead, prior to a charge conference, prior to presentation of trial defenses and evidence. This is not the time in any of my experiences that you're submitting to the court jury instructions. It's really bizarre. And then, and this is a little poke back in my interpretation by Judge Cannon at Jack Smith. At the end here, from Judge Cannon's ruling, any party remains free to avail itself of whatever appellate options it sees fit to invoke as permitted by law. Done and ordered in chambers at Fort Pierce, Florida, this 4th day of April, 2024. This is just so unusual. There's nothing normal about this. I can't recall having read a document like this or experienced anything like it. And again, in my conversations with other attorneys, that's generally their answer as well. So what happens? So what's the good here? The good here is Presidential Records Act charges stay in the indictment. The bad news in this is Judge Cannon is not letting go of this jury instruction issue, which is going to make it harder and harder and harder for Jack Smith. We don't even have a trial date yet in this case. It's been going on for a long time. This judge continues to give what appears to be a lot of deference to the defense, significant deference to the defense, and very little to the prosecution. Not that she has to give deference to the prosecution, but typically if you're going to give deference, and just bluntly, my experience in the Central District of California and the Southern District of California, where I practice, judges are exceptionally fair. I have not observed judges really what appears to be favoritism to one side or the other. I know people love to attack California for one reason or another, but the federal judges in California, my experience is I haven't observed preferential treatment in any way. And even in state court, while attorneys will disagree with judges' rulings, I just got to say, I have not seen what I would deem to be preferential treatment to the plaintiff or the defendant. I practice in civil court. And I just don't see that. So when I see a series of rulings that look like they're preferential to one side here, the defense, it's really, really odd. So what's next? Jack Smith has to determine whether or not there's something he can appeal. It doesn't look like this is an appealable argument yet. He still could go to the 11th Circuit, and it's an extremely high standard to ask for Judge Cannon to be removed from this case. The other problem with removing Judge Cannon that I think too many commentators are not thinking about, and people on the left who want to see, you know, anything happen to Donald Trump, which by the way, I would like to see him held to account for everything that he is able to be held to account for. I'm in that boat too. But the problem is, if you remove Judge Cannon and you bring a new judge in, that just delays this trial even further. It pushes it even further. There's just absolutely no way this thing is going to happen before the November election, before January 20th or so of 2025, when either President Biden, you know, is sworn in for his second term, or potentially Donald Trump for another term as well. And the danger in Donald Trump being elected in November is, of course, he would pardon himself. And that is something that our laws don't particularly contemplate based on my review of the law. So look, please give me your comments below. I love them. I read them. I do appreciate them. I want you to share this with your friends, your family, your frenemies. Hit that like button. Subscribe to this channel. And I look forward to talking to you next time. I'm Ethan Bearman for Really Legal on the Really American Network.